Mr. Moulin.
Good afternoon, my lord. May I proceed?
Yes, please. Thank you.
Thank you. Thank you, my lord. I would ask your lordships and your ladyships to turn with me to the bundle of authorities, and if they may, we are talking at pages 1263 onwards, 1236. And the case I would like to, I'm not going to read it, but I would just like to remind you, there was a Mauritian gentleman who tried his best to dissociate the land from the water rights. That was Mr. Colin. In 1889, he tried to sell the rights to the water and reserve it to himself. Sell the land, reserve it to himself. The court said 2-3, he could not do so. Said he could not do so. In 1891, he tried to lease it. And the court said 2-1, well, he could not lease it. One said, well, he didn't see why an assignment should not be made if it didn't change the user. But so be it. Today, we have authoritatively from those days that you cannot sell or lease that right of water without going back to the court. I will obviously allow your lordships to read them in their own time. They are at pages 1264 and 1273. JCPC and Carsonac was the first case which came before our courts after 1863 and explains very clearly the genesis of the act. But I believe the report of the Procureur General Dixon is just as adequate. Just to stop there, I had referred at some point on a note of the Procureur General Dixon, and that was note, well, I'll find it in a minute, but I believe it was on sections 7 and 8, and the note, sorry, it's note 28 at page 74 of the supplementary bundle.
I'm sorry, could you say the page again, please?
Page 74 of the supplementary bundle. I will not read it, but page notes 28, 29, and 30 was the issue of irrigation and how it was distasteful to many persons who had those concessions, and why that paragraph 7, now in paragraph section 10, was introduced in the Act.
Could you just explain briefly what these notes by Procureur General Dixon are actually? What is he reporting on?
Well, the interesting part, my lady, is had it been done before the introduction of the law, I would have called it the travaux préparatoires. I have tried to understand from my learned friend, Mr. Raymond Juniaville, QC, who is the historian of the bar and who's written on the Code Civil extensively, why it was afterwards. He did not remember exactly, but he felt it was akin to it. I may not answer specifically, but I believe it was for the Governor General to be apprised, and the Colonial Secretary through him, the Colonial Secretary to apprise the Governor General of what law had been passed and what was its effect when they were important, because petitions would come to the Governor General, and therefore it was necessary that he had some report to be able to follow what had happened. This is my understanding of it. But I believe when you read it, it sounds to me from what would be today the Attorney General, a travaux préparatoires.
And is this generally relied on in the courts in Mauritius as helpful or authoritative on the meaning of the legislation?
I do not believe it is, my lady. I haven't seen anything on a rapport, but my learned friend, Mr. Souzé, will tell me whether he disagrees or not. But my view is that specifically, it would be an aid for construction as to what was the intention of the legislature at the time. So I was speaking about Colin and how ingenious he was to try to dissociate it, but lost twice. The next case...
Could I just ask Mr. Moulin, forgive me, would Procureur General Dixon have played any part in the passing of the legislation?
It seems he did, my lord. When you read it, from the tenor of what you have, it seems he did. But I do not have any information on that. And I did ask Mr. Juniaville, who could not assist me. But he
Yes.
believes his office would have been responsible for drafting that law. Yes, indeed.
Thank
Yes,
you.
my learned junior is more diligent than me, my lord. At page 71, she draws attention to note 8. The Procureur Général, with the assistance of the committee, prepared the draft of a new law, which was led before the Council in November 1861 and published for the information of the public. Many observations on it were submitted to the board, and these with the draft ordinance were referred to the same committee and occasioned several amendments to the draft. So she is correct. It was the Procureur Général who drafted the law, as the Attorney General would today.
Thank you.
My lords will remember the next case which came was Rouget and Feyafé, where the issues have already been discussed. I will not go back on it. I've read it on the last occasion. But what I would like your lordships to have a look at with me would be the case of Yemen Sugar Estate. At page 1281. It is a review in 1939 of all those laws, and it shows how it's been adopted over the years. And a number of matters are set out there. The part which I'd like your lordships to refer to is page 176 of the judgment, 1299 of the record. This is the third line. It is the court now setting out which are the principles they evolve from the prior case law. These principles are: 1, our local ordinance is to be read and construed with these articles of the Code Napoleon, especially the original Articles 641 and Articles 644 and 645, which deal with similar matters. 2, the right of riparian owners of land cross or pass by our rivers through the use of these waters confers upon them no property in these waters, taking the word property to include all the higher attributes of ownership, such as are thus defined in Article 544 of the Code Napoleon. Le droit est la propriété, le droit de jouir et de disposer des choses de la manière la plus absolue, pourvu que l'on fasse pas un usage prohibé par les lois ou par les règlements. Property is the right to use and dispose of things in the most absolute manner, so long as you do not make a usage which is prohibited by laws or regulations. In the application of these general principles to specific issues, these judgments have held authoritatively that the co-borderer cannot reserve to himself permanently or sell to another co-borderer his rights to irrigation waters, nor can he lease out these rights. I do not propose to go much longer into all of this to establish what I wanted to say, but your lordships may wish to look at pages 180 of that judgment, 1303, the reasoning based on Dalloz, why they come to those views, simply to say that the proposition of law, in my humble submission, is that waters must be considered public property, and trying to isolate a user of water different from which has been given is contrary to public policy, in my humble submission. My Lord, may I respectfully now try to move on to the issue of time bar and prescription. My learned friend is correct to say that you must turn to Article 2229 of the Civil Code. However, it is for his client to show that the 5 elements of Article 2229 have 2227. Pardon? 2229 are satisfied. And what are they? It is at tab 7, page 1189, and page 1066 for the translation. 1066 would be more useful. To be able to prescribe, there must be a continuous and uninterrupted possession, peaceful, public, unequivocal, and as owner. Now, I pause there for a minute to say that you must believe you're an owner. And asking for an authorization is anything but believing that one is an owner. And I will come to that a little bit later. So the expression à titre propriétaire has been said time and again in the commentaries as animo domini, means that the holder of the right, it was incumbent on the appellants to demonstrate that those conditions were satisfied. Well, they only say that they had a right in 1888 that they cannot trace, and that right was somewhat increased or added to in 1939, but the original right did not disappear. Well, the simple answer is whoever holds property as a right derived from another cannot prescribe against that person unless he ascribes adverse possession. I mean, and I think that here, how would they have asserted that adverse possession? They must tell us that we do not recognize the right of the state anymore, and this right is ours. If they say that they could prescribe the right to draw the water, and I say they cannot in principle, but if they could, they must prove adverse possession. They must prove they interverted their title, that they prescribed against their own title. And that they do not say. They simply said, I had a right granted to me. Well, obviously, if a grantor has given you a right, tell the grantor that I refuse to recognize your right. That is how you establish your possession, and if I may simply say so. Continu et non interrompu, paisible, public, non équivoque, unequivocal. You must state that you refuse my right as an owner, the right of the state in that property, and I claim it for me. And I would like here to turn to Article 2236 of the Civil Code at page 1190. With la traduction. I think there's no translation, so I'll translate it as I go along. Ceux qui possèdent pour autrui ne prescrivent jamais par quelque laps de temps que ce soit. Ainsi le fermier, le dépositaire, l'usufruitier et tous autres qui détiennent précairement la chose du propriétaire ne peuvent la prescrire. Those who possess for others never prescribe for any period of time whatsoever. I draw attention, my lord, to the words, those who possess for others. That is exactly what it is. The possession is, you are exercising the possession of another. He has got the title to that thing, but he's allowing you to use it. So you possess it through their title. They possess for others. Ceux qui possèdent pour autrui, for another. Thus the farmer, the depository, the usurpatory, and all others who precariously hold the property of the owner cannot prescribe it. Obviously, a precarious owner, a precarious holder of rights cannot become an owner. And it is my client's position that Ciel knew well that it held the rights by reason of a juridical act, namely the authorization to draw water. That fact itself acknowledges the property of the water to that and another. It could not prescribe it without coming and claim to be the owner. Both the lower courts held that Ciel and both appellants could not have acquired the proprietary rights by prescription. And I believe that this is obvious when you look at the whole of the evidence. There is not much to say except it's been there for a long time. But there is no element of adverse possession which has been put forward. In that, I would like now to ask your lordships to turn with me to the, again, the supplemental bundle of authorities, where I have tried to translate the Dalloz Répertoire Pratique. And it is at page 85 of the supplemental bundle. It's on prescription civile. I will not read the French part. I will read the notes 82 to 86. What is imprescriptible because of their destination? Those, note 82. Those matters that cannot be prescribed by reason of the destination user constitute the public domain and its dependencies. Possession, even immemorial, is ineffective in obtaining a right of a property within the public domain. The imprescriptibility of a property in the public domain is a matter of public order and may be raised for the first time before the Court of Cassation. However, a long possession, together with other documents, may give rise to the presumption of existence of a right in public domain. And that has been adjudged, my lords, for arches and covered parts protruding over a street. So it is, to my mind, to be restricted specifically to that type of issues in cities. 84. On the other hand, the imprescriptibility of property which is part of the public domain can only be invoked by the state, department, or municipality in whose public domain the property is placed. Individuals cannot avail themselves of imprescriptibility of property in question because they're not representative of the public interest. So the public cannot claim the imprescriptibility. And note 86. The imprescriptibility of the public domain does not only prevent the acquisition of the property of these matters which form part of it, it is also an obstacle to local residents being able to acquire easements there other than those drawn from the local situation. The active easements belonging to the building are also imprescriptible when they're exercised by means of visible structures. Now, what is the servitude, the easement here? It is the right to draw water. It is an easement. It cannot be otherwise. And therefore, that right, this easement to draw the water, is imprescriptible. Whatever my learned friends' clients tried to do, and I believe they haven't done much, to be honest, whatever they tried to do, they could never have acquired title to that portion where we allow them to draw water by means of this aperture in the dam on the river Tatamaka. That is the property of the state. That was the property of the colony of Mauritius. It was a right to draw water which was given, and that right cannot be prescribed. When we turn to the répertoire pratique still, prescription civile, in the bundle of authorities at page 1603, but in the same supplemental bundle, I have translated it at page 88. I would wish your lordships to read note 103. On ne peut acquérir par prescription le droit, premièrement, de pratiquer des saignées. The saignée, my lords, is just like somebody is bleeding, which is to saigner, what that means is that you open up the side of the river to allow the water to bleed out. And I've translated as follows. The following rights cannot be acquired by prescription. First, to make a channel to extract water or make it flow. And then the rest follows. But what I take from that without any difficulty is the canal. I do not know who built it. I do not know when it was built. I can only say that it is possible it was there in 1939, because when you read it, it seems to say that it's drawn to the river by a canal and brought back to Tatamaka from something which is not too far away. How it is brought, it is not said. But let us accept it was there in 39. The right cannot be acquired by prescription to make a channel to extract water or make it flow. You cannot do it. So whoever built that channel could not prescribe the right itself to extract the water. As I said, the necessary part of an adverse possession to go against your own title.
Just before you move on, if I may, does your submission go as far as to say that you can never acquire a right to extract water by acquisitive prescription?
No, my lord. In a concession, you'd be able to do so. Water conceded by title by the king before 1863, and those concessions being supported by title deed or lost, if you have a concession that is recognized, then that right to water may be prescribed by a third party. But I would say that in a normal situation today, or in the situation after 1863, you would never be able to prescribe the right to draw water. That indeed is my submission, my lord. If my lord would turn with me to page F9T, it is the translation of the Code Annoté this time. My lords will remember the Code Annoté takes each article of the Civil Code and explains what it is. So now we're dealing with Article 2238, the interversion de titre.
And which page are we at? Which page?
Page 90, page 90 of the supplementary bundle. I'm only giving the translation. I'm not going to the bundle itself because it's in French. Characters of intervention of title. Note 1. A reversal of title occurs when there has been a change in title by virtue of which an individual owned property. In other words, possession is inverted when, having begun with a title other than that of owner, it changes into a possession whose advantages are reaped animo domini. Users 25. The reversal of possession results in converting a simple precarious detention into possession animo domini. And in particular, detention for use can only result from patent and unequivocal facts of a nature to contradict the owner's right. Now, this is an important piece of law which has been declared by the Chambre des Requêtes, Décembre 28, 1857. It is not new. That principle is settled law. In particular, this reversal cannot result from a few abusive acts, which, being confused with a precarious detention with which their author was invested, are rather a simple extension of precarious detention than a contradiction of the right to property. For there to be, note 27, for there to be a reversal of titles, there must be an act of hostility addressed directly to the beneficial owner. Note 32, the reversal of title cannot result in the benefit of a common user or that the encumbered timber has been registered and taxed under its name. 35, nor by an act by which the user would have assigned his right to a third party, qualifying them as property rights, especially since the enjoyment of the purchaser was in conformity with that of the seller. And that is why I stated earlier to your ladyship and your lordships that the actual sale by Refac to Ciel was in contravention of public property, and it cannot confer any more rights that Refac itself had. I do accept that if Refac had the rights at the time to run the factory, if those rights were still the same, it would have been effective, but they were not the same, so they could not do so. I will not read the whole of page 92, which again is the code annoté regarding article 2240. It is the impossibility to prescribe against your own title. There's only one word I would like to point out to in note 2. Amphithéote means a person holding a 99-year lease by amphithéotique, simply for your lordship's reading later. But I would like your lordship to read with me note 11. Celui qui a obtenu de l'autorité administrative une concession d'eau soumise à certaines réserves au profit de la ville voisine ne peut invoquer la prescription contre la ville qui se prévaudrait de ces réserves après plus de 30 ans, ce qui serait prescrire contre son propre titre. Anyone who has obtained from the administrative authority a water concession subject to certain reserves it should be reservations, subject to certain reservations for the benefit of the neighboring city, cannot invoke the prescription against the city which would avail itself of these reservations after more than 30 years. That would be to prescribe against its own title. The rest may be read, my lords, in your own time, my ladies. I will not go any further on it. It is sufficient for my purpose to have shown to your lordships, and I hope make them agree with me, that not only is it imprescriptible, but there was no possibility in law for the Ciel estate, for Réunion to prescribe and Ciel to acquire that prescription, because it is simply against public policy, whether on the act itself or under the law as put forward by the Civil Code. There are a few facts which may be of interest to your lordships, and those facts are documents E12 and E15 at pages 438 and 441. This is a survey by the FAO, UNSF, and the FAO at the time wanted to investigate the water sources in Mauritius in 1966. And my client prepared a survey. And when you read the survey prepared by my client at those pages, what do they say?
The date of this, Mr. Moulin, is 1989?
1966.
Oh, right.
Page 438. And when you read the document, my lord, you will see this is prepared by my client for this United Nations project. And at page 439, at the bottom completely, authorization granted to draw 9/10 of River Tatamaka and the whole of Rivulet Saint-Martin for the estate factory, the water to be returned to the river. And at use of water, at 16B, you can see use of water 3, it says mill. You can't see the head works very well, doesn't write it very well, but you can read, you can see that this is, there are at documents E13 and E15, a description of the dam that we have seen earlier and of the masonry works which are there. So that is my client's record of the water right. And they only speak of the 1939 water right, and they do, under pages 438 and 440, speak of Réunion Limited as being the owners of these water rights. But let us now move to what Réunion itself declares when I ask them. My client says, you must tell them what your water rights are. Now that's the more interesting part, remembering that we must have a possession animo domini. Now what do they say? And my lord will turn with me to, my ladies, to page 486, document H60. Central Water Authority, sample Phoenix, notification of water right. Dear sir, your notification of a claim to lawful water right dated in 1981, I think it's 22nd of January 1981 from my notes, but it's not very readable, is acknowledged and has been recorded in the register of notifications as number so and so. This acknowledgement should be kept as proof of your having notified your claim. The secretary, etc., Réunion Limited. What does H61 say? Full name of the claimant.
Mr. Moulin, I'm afraid the network went down for a moment.
Yes.
I'm afraid the network went down then.
Yes.
We're at page 486. If you could start again, please, I'd be grateful.
Yes, my lord. It was a notification of a lawful water right made by Réunion and an acknowledgement by my client on 22nd of January 1981 that this water right had been registered by the CWA. And it is Mr. Kopemutu, the water rights administrator, who writes to Réunion Limited to say so. And when you turn to page 48...
Where do we see the details of it?
If you were to turn to the next two pages, my lords. Pages 487 and 488. You will see the claimant is Réunion Limited. They claim for water right on River du Ménil for irrigation. They give the land to which the right is attached. And that, I believe, answers the question of my lord Burrows. Is the right attached to land? Yes, my lord. And you must declare which land it is attached to. It is the date of the grant, 1880. So, my lords, my ladies, we know when it arises. They do have their rights. They can say where they've been granted after 1863. And they say which land entitles them to those rights. And they then say proof of lawfulness, report of division of 10 Williams River by Dejoux, dated 26th of January 1876, homologated by Land Court Order of 13th of January 1880, Supreme Court Record number 876494, judgment of 7th of May 1959, etc., etc. I'm not going to go through them, but both of them are first for River du Ménil, the second for River Sèche and Source Clairfond. There is no other declaration. My client in 66 stated there's a 1939 right. But somebody who will sell those rights shortly afterwards, this is, remember the date, 81, does not declare in 81, I have water rights in a canal which is my private property. Now that cannot be possession animo domini, not when you have an obligation to declare your water rights. Remember that my client is authorized under section 20 section 20 of the Central Water Authority Act, 22. Okay. 1. Establish procedures for the recognition of existing water rights for the reassessment, reallocation of existing water rights, and for the grant of new water rights. So this is exactly what my client did. I'm asking you to declare your water rights because I am the lawful person to whom you must declare them, and I'll keep a register when I'm going to look at it, and if I come with anything to do later. Why are those rights not explained? There can only be one reason. They did not believe that they own that title. That is the first issue that I wanted to draw attention to. And the second one is that they requested permission to use the surface water on 2nd April 1987 at record at page 489. I'm not going to read it, my lords. We may do so in our own time. And but it is at page 489. My friend is quicker than me. Document J. It's number 2. Dear sir, with reference to the letter, etc., etc., we would be pleased if we could be granted permission to use the surface water, i.e., from rivers Saint Martin and Tatamaka, for our new factory, Floreal Knitwear Limited. Now, would a person having a possession animo domini request for a right? The answer is in the question. And when faced with those questions, Mr. Noel simply stated, I cannot say. The last point I want to draw your lordship's attention to is the fact that the appellants paid for water charges at the rate of ₹1.50 per minute between July 1989 and November 1993. There is a small discrepancy for December 93. We can ignore it because it's only 1 month, but I'll come to that later. So we'll accept, therefore, I'll leave December 93 out. But the record shows that between July 89 and November 93, everything had been paid at that rate. There was first a first claim which was paid by check, and a second claim paid by check. We were estimated amounts, and then there were returns made. The fourth point I want to put to your lordships is the following. The appellants acknowledged receipt of a meter from the CWA and informed us that they were going to install it. It will be operational from 19 September 1992. Document BC, page 585. Now, why would they tell the authority that they received our meter to install it on that preserve, on the canal? If it is theirs, what is my right? Just simply to check? Because it's a water, 9/10 flow from a dam. We know what is the amount of water going through, so the share is always there. You don't need to calculate it. If you have an opening in the river, the very fact of having a metallic plate is to allow only that amount of water you're entitled to go through without actually measuring it, because the flow is constant. So why would they then install a meter if it is not for the purpose of paying for what they use? This is the fourth point I wanted to leave to your lordships. And in November 92, the appellants informed my client they would provide monthly records of track for the borehole and the river at the beginning of November, and that the application to draw water from Tatamaka was in progress, and that Sigma had been contacted to provide an expert report. That is document BC at page 585. And it is only in 1994 that the appellants right to say that the water for which they are paying ₹1.50 per cubic meter may be private property, document BG. So before 1994, January 1994, that ominous letter, there was nothing in the manner in which the appellants approach their rights, which is suggestive of an interversion de titre or adverse possession. On the contrary, it is in keeping with a holder of a lawful right seeking permission for the water resources manager of the country. The behavior for more than 7 years, from 86 to 94, is therefore not consistent from that of an owner. And I've already stated to my lords and my ladies, le droit d'user de la chose, de la manière la plus absolue. Le droit de jouir de la chose, de la manière la plus absolue. And le droit de disposer de la chose, de la manière la plus absolue. Those three things of using comment dit jouir en anglais? Enjoy the possession and sell the water. Those three matters is not in their possession between 86 and 94. How can they claim all of a sudden going back, and how can they say today that for 100 years nothing happened? They never showed anywhere that they had changed their title. Well, as I believe I have done on the matter of prescription, the next point I wanted to go into was the issue of the payment. My friend has stated time and again that there are no regulations. I acknowledge that. And I acknowledge that there has been no regulation passed for surface water. And I also acknowledge that since the 1980s till today, it is still being prepared. At some point, probably the minister will awake, but it hasn't done so yet. But the point is not that. The point is, may my client receive other revenue? Or is he bound, is my client bound only as contended by the appellants by section 24(1)(a)? And if your lordships were to turn with me to the Act. Combien? Page 1164. The authority may receive revenue accruing from rates and fees to be levied under any regulation made under this Act, loans, and C, any money properly accruing to the authority from any other source. Now, is it to be construed that because I have a power to receive money from revenue from rates and fees levied under a regulation for water, my client has absolutely no right to come to an agreement as regards a user of water which is not prohibited and which is in fact beneficial to the country? And this is the point. And this is also the fact that you have seen that other persons are paying the same rates, and that this is not... Yes, sorry, milady.
Yeah. I really want to be clear about what you say is the source of your power to ask for this payment, because you've described what happened in 1987 to 1989. And as I see it, although there was a lot of discussion about entering into an agreement, there never was actually a binding agreement, because it needed, according to your client, the approval of the Supreme Court. So I don't understand that you're relying on some binding agreement between you and the appellants, because I understand your case is that you are not empowered to confer rights. It's the Supreme Court that has to confer the rights. So where does your right to ask for this money come from? Is it implied somewhere in the legislation, or what does it arise from?
Your ladyship is correct. I cannot resist that inference that your ladyship is making. It is a difficulty of my case, but I must say that the payment of water charges has been agreed upon, and if we were to accept that this agreement arises between two parties and may be the subject of civil rights, it is not specifically prohibited by law. So in those circumstances, milady, not being prohibited by law, would the court, therefore, in that case say, well, the fact that the user by the appellants of that water was not in conformity because they did not obtain the proper sanction of the Supreme Court, but they have used it and have not been able to stop them by reason of the fact that no injunction was ever granted. But it still happens that it does not make the contract made, the agreement reached, against public policy. It would not allow a person to use until the end of a case, and I did ask for the judgment to be applied and water not to be drawn before the Supreme Court. When you read the case at the level of the Chief Justice, I did ask for the water, that the judgment be not suspended and that they stop drawing water. Well, I was not allowed to do so. So we are talking now for over 30 years of drawing water, and unless your lordship feels that the the essence itself of the contract is against public policy and is illegal, in that case, my client may not recover those monies. But if your ladyship feels, yes, milady.
Well, it's not the question of whether the contract is illegal. It's that I'm not sure that you can agree to take money for water which is being unlawfully drawn from the river, because that doesn't seem to me something that the Central Water Authority should be doing. Agreeing for payment for the drawing of water, which is an unlawful drawing of water. And your case, as I understand it, is that the drawing of the water was unlawful because it was without authority.
That is correct, my lady.
Yes, so that's what I'm struggling with. I mean, I could see that you could say, well, as the controllers of the water resource, if somebody unlawfully draws water, then they must pay for it, and the obvious person to whom they make that payment is the Central Water Authority. But I'm just trying to, but that wouldn't be relying on that kind of agreement, other than to say, well, that shows that ₹1.50 was a reasonable amount, and so that's the amount that we can charge. But doesn't the entitlement to charge, or rather the obligation on them to pay, arise from the fact that they, on your case, have been unlawfully drawing this water from the river?
It would arise, milady, obviously as stated by your ladyship, but the idea I had in mind is the enrichissement sans cause. They would have been able to obtain a benefit without any counterparty. And I believe that would be probably in civil law the manner in which it ought to have been, it should have been followed. But I must say this is not the case I have presented to the Supreme Court. This is not the case I've put forward, and I'm bound by my case. I must say where I am. But the alternative view, the view of your ladyship, certainly would enable me to obtain that amount. But I did not present it before the Supreme Court.
Well,
it would be totally inequitable.
The premise relied upon by the appellants, they started with section 20, which is at page 1160. And they said that the authority is the body responsible for the supply of water. But if they have been unlawfully extracting water, then they are themselves in breach of that section, because they've taken unto themselves the unlawful supply of water. So in that sense, it might be some form of breach of statutory duty or a civil wrong, because they are performing the function that should be performed by the Central Water Authority.
Stevens is correct.
I'm so sorry, I didn't want to abbreviate the answer. Did you want to?
My Lord Stevens is right, milady. What I wanted to say, milady, is that my Lord Stevens is right when he says that it's a breach of statutory duty. Your ladyship will remember that in civil law, a breach of a statutory duty is automatically a wrong, a délit, and therefore actionable under Article 1184, 1384 of the Civil Code, 1382 of the Civil Code, and as a faute, therefore a tort under English law. And that is, however, as I say again, milady, I have the difficulty that my case is, when you read it, my case is only for monies. It is not predicated on anything other than payment of amounts due. So I must acknowledge that difficulty.
In English law, we sometimes use the concept of waiving the tort and suing in contract.
As I say, milady, I would then base it rather, I would rather remain on the tort, but when we read the cause of action, the cause of action, which is at page 8, the paragraph 812, page 9, The defendant number has been consuming water and has failed to pay for same. That is my cause of action, and I cannot say otherwise. I've got to stay where I am. I cannot change it, but it would be rather inequitable that after 30 years of use and nobody having granted me my injunction, I'm already being told that I should not be able to obtain that money. But that is obviously a matter for your lordships.
And this point has not been taken by the appellant, this particular point.
No, milady, it has not.
That the sum is not properly quantified.
No, milady. In fact, it is properly quantified, and I'll come to that later. The last point, my lords, miladies, is on the issue of time bar. Now, before I go on the issue of time bar, I need to address the pleadings. And if your ladyships and your lordships would turn with the pleadings, I think they are extremely important to bear in mind. Would your lordship and ladyship turn with me to the plea and the pleaded case of the appellants at page 66. I read plea B2. The defendants admits the averment set out in paragraphs C, D, E, F, and J of the statement of claim. And that's extremely important, and I'll explain why it's important for my case. If your lordships would turn with me and your ladyships turn with me to the amended plaintiff summons at page 312, let us read those admitted facts. D, by error and a confusion between this case and another case of the CWA, the undersigned attorney wrote to his lordship the Chief Justice as follows. I have been instructed that the case is being settled between the parties.
So, forgive me, Mr. Moran, where are you reading, please? 312.
I apologize. 315, at page 315, paragraph D, which has been admitted by the plea as I've just stated. So the pleaded case is that this is admitted. So the error and confusion is admitted. Now, it cannot now be said that somehow this arose otherwise than an error or confusion. So when I say it was a confusion, I believe this is an admission already made. Now, Mr. Virasamy, late Mr. Virasamy asked because the case was being settled to remove it from the cause list. And on 25th of July, the circular was received, and consequent to same, the case was struck out. And the plaintiff then queried about the fate with his attorney, and the error was found out. And at paragraph H, the plaintiff's attorney immediately wrote to the defense attorney with a view to reinstate the case. And I, which is also admitted, all those are admitted, the plaintiff's attorney has received a letter from the defendant's attorney, worded as follows, etc., etc. Refer to your letter. Following the decision of the CW to strike out the above-mentioned case in July 2003, we are not agreeable to have the request of the CWA in order to reinstate this case. On the other hand, we have no objection that they present a new case. And when you read both cases, they are exactly the same. There's not a word has changed. And that is the important part. Now, the important part is all those are a mistake, an error. What is in law the fact of withdrawing a case? It can only win one of two things. A désistement d'instance, that is, the proceedings abate, or a désistement d'action, that is, you purely and simply renounce the right of action. And what does the law say? And I'm not going to read my statement of case. I'm mindful that I've overstepped quite a bit on the allotted time. But what does the law say on the désistement d'instance ou désistement d'action? Désistement, pure simplement, to desist yourself. It must be unequivocal. It can be done in a number of ways, but it must always be unequivocal. And there's one thing which is certain, that the error was not unequivocal. It is an admitted fact it was an error. If it is an admitted fact that it is an error, what are the consequences of that error? And here, I would ask your lordships and ladyships to turn with me to the Où est-ce que t'as mis ça? The state of case. page 1690 of the authorities. Notes 38 and 45 of Dalloz, procédure désistement. I'll translate those two notes. La volonté de se désister doit en premier lieu être réelle, elle doit en second lieu être exempte de vice. First, the will to withdraw must be real. Second, it must be exempt from any defect. 45, la volonté doit être exempte de vice. Ce vice pourra résulter d'une erreur sur la cause du désistement, notamment lorsque l'appelant se désiste de son appel dans la croyance erronée que le jugement dont il était appelé avait été rendu en dernier ressort. The will to withdraw for a claim must be exempt from any defect. This defect may result from a mistake on the cause of the withdrawal, especially when the appellant withdraws his appeal under the mistaken belief that the judgment which he appeals is a final decision. And at page 1717, note 48, verbo erreur, Dalloz Code civil. De même, le désistement d'action est annulable lorsqu'il ne constitue pas l'expression d'une volonté éclairée de son auteur qui était victime d'une erreur. Similarly, the withdrawal of a claim is voidable when it does not constitute the expression of the clear, informed will of its author who has been the victim of a mistake. And the Cour de Cassation, in the bundle of authorities, you will see at page 1402, the only authority I want to refer your lordships to. 1402. It's the last authority on that bundle.
Mr. Moulin, you're going to have to draw this to a close now. I did say
yes, I'll go very quickly.
10 minutes, but yes. You're well over that now, I'm afraid.
I shall do so. So it is simply to say that simply le désistement effectué par erreur est nul. So the law says very clearly, and at that authority, that a désistement which has been properly made is null and void. What are the consequences that the désistement was nul? It means that for the time that the original plaint with summons, or the statement of claim rather, was into existence, the prescription period, the time bar, was suspended. It did not operate. So the time bar did not run at all during the period of between the two times, 1996 to 2003. And therefore, the claims which are allowable are 3 years prior to that date or 10 years prior to that date. I have explained why the 10-year period is the proper one, is because there is no, in order to fall under the Article 2279 of the Civil Code, which says that in order to prescribe, you must, if you interest and other amounts payable by regularly, periodically, and intervals of less than 1 year are prescribed by 3 years. This extinctive prescription created by Article 2279 may only apply with two conditions. Firstly, that is periodical. Secondly, that it is fixed. Fixity has disappeared nowadays to come and say it must be ascertainable. Now, you could say you could ascertain it if it's 1 rupee 50 per minute, per cubic meter. But what is there, and what is shown by the evidence on record, is there was no fixity. The first payment was for in 1992. The second in 1992, yes. The second payment in 92 again, and the third payment as and when on 5 different occasions, as shown by document BO, on 5 different occasions in 1993. So there was no fixity. There was no definite time period for payment. And why is that? Is because the obligation to read the water meter was that of the appellants and not that of the CWA. And you remember that the water meter reader who went there said, I only went to read the water twice. Once, I don't remember the date, 1 year before, and just a few days ago before coming to court. So it shows that there was, although it may have fallen under Article 2279, the very first part of there being a regular payment was not present because the payment was irregular and not at fixed time periods. So it fell outside the date of outside the elements of Article 2279. These, my lords, are my submissions, unless I may have any further assistance.
Thank you, Mr. Moulin. I don't think there are any further questions for you. We're very grateful to you. Could I call now then, please, on Mr. Sauzier to reply?
Yes, my lord, I'll try to be as concise as possible. Just to answer a few points raised by my learned friend. First of all, I must say I was surprised to hear him mention that the deed with regard to the sale from Société Refac to Société Réunion, which is document K at page 491, where the water rights are mentioned, was illegal. That is, it contained illegal things. This has never ever been mentioned or suggested before the trial court. In fact, this document has been produced by the plaintiff, now the respondent. I was never made aware that the contents of this deed could embody something which was illegal. This is my first point. The second point is I've not heard my learned friend addressing your lordships on the main issue of this case, that is the canals, the part 2 of the Rivers and Canals Act. He seems to have forgotten, I'm sorry, my dear friend, section 32 and section 33, because this is the crux of the case for the appellant. Now, when we read through this Rivers and Canals Act, section 32 and 33, which I believe is at page 2. Sorry about that. At page 1126. Lords, it is clear that this is law, and this law provides concession, apportionment, or prescription. I totally agree with my friend that when we speak about rivers and streams, this is du domaine public. It cannot be prescribed. And the gist of my learned friend's submissions was leveled at rivers and streams, not at canals. Why would the word prescription or prescriptive titles exist in section 32 and 33? I mean to say that you can only press. Yes, my lord.
I'd understood you to accept that you couldn't have prescriptive rights in relation to the water in the river before it enters the canal. And I also understood that you accept that you can't have prescriptive rights in relation to the water once it's back in the river. And I also understood you to be accepting that there was more than likely, or probably, or definitely, a condition that the water that was removed from the river was returned to the river. And so I have difficulty in understanding how you can get prescriptive rights in circumstances where it's public at the beginning, public at the end, but in the middle, in some way, it changes its nature.
This is why I referred your lordships earlier on to the case of, that is a case I mentioned earlier on, where Lord Justice Muir said that what remains, what was public becomes private when it enters the canal. This is what was said in this judgment. I might get back this judgment to you.
Colin,
I'm sorry.
it was Colin.
Yes, it's particular.
Colin.
Exactly. Colin. So
But
this is the concept. Question would be, you can only prescribe what is private. I cannot prescribe something which is public. It is impossible. So I cannot prescribe water on a river. This would not be possible. It has to be in a canal. So for me, the crux of the case is the application of section 32 and 33. And this has not been addressed by my friend at all.
Yes, but that's because the right to extract water from the river is public property, and you cannot prescribe that. So your canal is not much use because you can't get the water out of the river, because that is always public property.
Then, Melody, I'm sorry, then the existence of section 32 and 33, this should be abolished because all the canals in Mauritius.
I don't think so, because it's dealing with disputes between those who border onto the canal. I assume it's the same word. It's dealing with the rights of parties who claim portions of water from a canal. It's dealing with their situation among themselves, or a third party who comes along. It's not dealing with the right as against the state.
My lords. So
That's my suggestion.
Yes, if I may, Milady, when we speak about prescription, so it means that the water which is in the canal must be private, because I cannot prescribe a public right. I cannot. So there must be the conversion from public to private. At a certain, I agree, Milady, that I said so, that the water flowing in the river is public. There is no doubt about it. But when I've got the right, this is the case of Yemen and Maga, where this principle is accepted by His Lordship, Mr. Justice Konai, when he says, if there is water in a canal and it has been properly withdrawn from the river, I was not ever, the appellant was never accused of having illegally obtained the water from the river. There was an order which has been homologated. Unfortunately, we haven't got the conditions, but all the procedure to extract water, to get the water into the canal, was legal. So long as it is legal, the public right is converted into a private right, because I've got the right to prescribe it. This is what I think that the respondent have failed to show to your lordships today. This is the first point. The second point concerns the supply of water. That is the part of my submission, section 20 and section 22 of the Central Water Authority Act. Has there been supply on the part of the CWA? There has been no answer to that. Were there existing rights of water? There has been no answer to that. If we go to section 22 of CWA at page 1163, there has been no answer. If there were existing rights of water, there were, according to me. And this is where section 24C at page 1164 obtain any money properly accruing to the authority from any other source. This would apply to section 22, or even to compulsory acquisition of water, where, let's say, section 21J, which is at page 1162, they have got the right to do it, but then they have to pay. This would be one of the conditions. Also, I wanted to stress, my lords, just before ending my submission, that there is nothing to suggest that there was something illegal in 1939, because when we look at the court order, which was given at page 436, this is the subsequent to the report of Mr. Hall, 436, it clearly speaks about water being flown into a canal. And if we go to the report of Mr. Hall himself, to answer to your lordship's question earlier on, when we go at paragraph 4 at page 429, paragraph 4, it speaks of the share of Réunion factory is now much less than stated above. So they speak in 1939 of a factory, so it was not for irrigation purposes. Secondly, paragraph 5, the estate Réunion has parceled out most of its lands. So it's clear that when we were dealing in 1939, that the rights which existed in 1888 and the surplus rights which were granted in 1939, it is clear that the acreage of land had greatly diminished in 1930. The last 2 points, my learned friend spoke about 2 documents at pages 487 and 488. obviously, these two documents have been produced. As far as I'm concerned, they do not concern Rivière Takamaka. They concern Rivière du Ménil, as my friend rightly pointed out, and Rivière Sèche. Secondly, the purpose of the use of water is clearly not the same as the use of water in a canal. It is irrigation. And I do not think that my friend was suggesting that the mere fact that there is no such document for the right granted in 1888 is that what was homologated in Supreme Court record 23737 would be wrong or did not exist at all. They existed. My submission is that they existed, and there is no document in our records going back to that time. The last point, my lords, is reference has been made to the appellants paying for water, to the appellants acknowledging, no, appellant number one has never paid for any water. Appellant number one has never acknowledged anything. Whatever discussion there was with the authorities was clearly started or carried on by appellant number two, which was then trading under the name of Floreal Manufacturing. This has been agreed and has been accepted by the learned judge in a judgment at page 354. You will see, my lords, that bottom of page 354, I agree, 355, with counsel for the defendants, that is for the appellants now, that the name of Ciel has not been mentioned on the documents. Throughout the correspondence exchanged by the CWA, it can be observed that Floral Manufacturing was addressed to Floral Knitwear. So, appellant number one never entered into any discussion or never paid any money to Respondent. And appellant number one was, in my submission, the party having rights in the as far as the water is concerned in the canal. This is my answer to the points raised by Madam Fellow. Thank you.
Thank you, Mr. Sauzier. I don't think there are any further questions. We're very grateful to you and to Mr. Moulin for your submissions this afternoon. We're also grateful to those sitting alongside you and behind you for the preparation of the case and for the assistance that they've given. We will take time to consider our judgment and will deliver a judgment in due course. Hearing is now adjourned. Thank you very much.